All right, hello everybody, and welcome back to another episode of the Litigators Network. We're so excited to have this amazing guest with us. It's actually someone with whom I was we were representing co-plaintiffs many years ago. No, not many years ago, right? Several years ago, and quite successfully. You know, the case has turned out very well for our clients, respective clients, and wanted to bring the great and wonderful Allegra Rineer on to our podcast to talk to us about sexual abuse cases and litigating those against school districts. So, Allegra, welcome to the Litigators Network.
Thank you, Kenny. Thanks so much for having me and allowing me to come on here and talk about the subject that I'm really passionate about and the area of law I love to work in.
Yeah, and you know what, in particular, I want you, if you could tell us a little bit about your background. I do want to say one thing is that I know that this is something that you are very passionate about, like you just said, something that you care about in helping, victims of sexual abuse. And it's so great to also see your career and where it's entirely focused on this and doing really the Lord's work and helping people out. So would you kind of give us a little bit of background about your career and kind of where you're at now?
Yeah, thank you so much. Yeah, so as Kenny said, I have been practicing in the area of sexual abuse litigation for now actually 10 years. I started out on the defense side, kind of like a lot of us do. And the case that Kenny mentioned that we worked alongside together on was my first sexual abuse case. I had that case in 2014. I think Kenny and I started working alongside each other in about 2015, 2016. And that first case really got me excited about this area of law. I didn't really have an interest in it otherwise, something I didn't really know about. And then getting to represent these children who had been through some of the worst things in life and getting to walk them through it and their families as well and get them on the other side to begin the healing process is just something that felt really inspiring to me. So I was able to have that case and a few others that kind of slowed from that one specifically. And then I kind of took a traditional PI route for some time. I've handled all kinds of personal injury litigation. And then a year ago, I actually got hired by Herman Law, where we exclusively represent victims of sexual abuse.
Yeah. And that's a national firm that's well known and has a reputation for handling these cases. And so we're very excited to have you on and talk to us about that. It's just helping folks as they go litigate these cases. And I think also consumers might be interested in their options, right? And what they can do if their loved one has been a victim of sexual abuse. So why don't we start talking a little bit about the law?
Sure.
There have been some recent developments in the law, and would you kind of talk to us a little bit about that and how that's opened up the path for people to be able to file these claims?
Yeah. So specifically, California passed a law that it changed a lot of sexual abuse litigation in the state of California. The first thing that it did, which was pretty profound, is it revived cases that had been previously barred by the statute of limitations. So that's often called a look back window. There was a 3-year time period where people who had been sexually abused 10, 20, 30, 40 years ago, whose cases may have already been barred by the statute of limitations, were able to be revived. So for that 3 years, plaintiffs could file their lawsuit and litigate a case that maybe they wouldn't have been able to otherwise.
Yeah. And so we have these look back sort of periods that allow people to do that. Now, I know there have been also extensions, right? In the particular code is CCP 340.1. There's also been a sort of an extension of the statute of limitations, whereas before it was a lot shorter. And now I think, rightfully so, there's been an extension. And can you talk to us a little bit about what that statute of limitation looks like now?
Yeah, of course. So that was another huge thing for victims of sexual abuse. Prior to, it's called AB 218. That was the law that changed CCP 340.1. Without getting in the weeds, all these letters and numbers. Those are the two things we focus on. But the statute changed from being 26 years old, which was the prior statute of limitations, to now 40 years old. So if by 2020 your statute of limitations hadn't run, and you'd say you were 24, now you have until you're 40 years old to bring that case. So that's a really huge thing for plaintiffs because a lot of people don't come forward. A lot of victims of sexual abuse never come forward. And often delayed disclosure is, I mean, that's the norm. So this allows plaintiffs some more time to come forward to tell their story and to bring a claim if they'd like.
Yeah, no, thank you. And so often we get, I mean, it happens to me a lot. I mean, it happened today twice where, people called and it's just like statute of limitations on not sexual abuse cases, but it's passed. It came and went, and they would have had a claim. They would have had a cause of action. They wouldn't have been able to file a lawsuit. But the timing's gone, right? Because maybe it was a 1 year, maybe it was a 2 year. And the fact that now there is a much longer statute of limitations for something that's just so hard on people, right? And it's difficult to address or even confront at times. I think it's wonderful because it gives people so much more time to do that.
Yeah, it's incredibly important. And I mean, it's, even now I'm litigating a lot of these AB 218 cases where my clients were abused in the 60s and 70s and 80s. And, they didn't want to talk about what happened to them. And now here they are at 60 years old for the first time coming forward and making these disclosures. And it's profound. And this experience is really healing for them. So although, statute of limitations isn't indefinite, allowing people some extra time until 40 years old is important. And I'm glad that the legislature decided to make that change.
Yeah. It's awesome. It's wonderful. And to some degree, it's a game changer. And yes, I think it probably should be longer, definitely. But at least it's something, right? It's an incremental change.
Exactly.
All right.
Another huge, sorry.
Go
I
ahead,
just want to, another huge change in the law that is important for litigating cases against public entities is the elimination of the claims presentation requirement.
Yeah.
So that one's huge. AB 218 actually, it's kind of an issue we're dealing with, but it retroactively eliminated the claims presentation requirement. So there were
really quickly. Yeah. So what is the claims again, because somebody just might not know, right? This might be something new, an area that they're interested in. What is the requirement? What does the government claim? Very briefly, you don't need to go into the details of it, right? And then how does sex abuse cases, your childhood sex abuse cases, and why is it important that that doesn't apply here?
Yeah. So generally when you want to sue a public entity, you have to comply with something called the Claims Presentation Act, where you essentially send a claim to the public entity and say, hey, I'm going to sue you. I'd like to sue you. And here's why. And you give a list of what happened, your injuries, and so on and so forth. There's the whole statute that identifies what you need to do. And there's a short time frame for which someone has to do that. I don't want to get into the weeds on that, but there's a short time frame. And if you don't do that, then you can't sue the public entity. That's generally the rule. Yeah. So with a childhood sexual abuse case, again, without getting too into the nitty gritty, what AB 218 did was eliminate that claims presentation requirement forever, retroactively as well. But moving forward, you don't have to present a claim, government tort claim.
Right. And it kind of makes sense, right? Because AB 218, like that the extended statute of limitations wouldn't work if you had to file a government claim in the first place. Even if you were 40, if it allowed you to file a complaint up until you were 40 years old, it wouldn't work if you had some sort of other requirement that you had to have filed, within months of the abuse taking place. So, this is a sort of round of applause for the legislature in getting it right. So it's not something that we have to worry about. Okay, cool.
Exactly. And just quickly, it's from 2000 and the legislature had already changed the claims presentation requirement, but that was only for abuse that occurred after 2009. Right. So that was 2009 looking forward, and what AB 218 did was get rid of it completely. So it helps, like you said, those other extending the statute of limitations would be meaningless if you still had to present a claim.
Yeah. Okay, so now we talked a little bit about the law. We talked a little bit about some requirements that are necessary anymore in presenting your lawsuit, filing your lawsuit. When it comes time to get ready to file that lawsuit, different causes of action, what are you grounding yourself on? What are some sort of the causes of action that you're looking at, where you're looking to plead, and who are you looking to bring in? Because when somebody might, think about sexual abuse cases and go, hey, aren't you only going to go after the perpetrator, right? The abuser, the person who did that. Isn't that the only person who's really responsible here? Why are we going after school districts, et cetera, et cetera? And what is sort of their responsibility? Why are they brought into all this?
Sure. So let's talk about a school district specifically. If you're dealing with sexual abuse by a teacher of a student, and that takes place, either on campus or off campus, but through the relationship of teacher student, the school is brought in through a negligence theory. The school essentially is responsible to adequately hire, supervise, and retain their employees. And if the school knew or should have known that this teacher was engaging in some sort of inappropriate conduct, then they are responsible for their failures and their failure to supervise or their failure to respond to complaints or red flags. And so the school district gets brought in for their own negligence and their failure to keep that child safe.
Okay. Yeah, and I think a little bit later we're going to ask you to give us some of your discovery tips, and I think a lot of it is geared towards that, right? Because how are we going to prove or show that the school district itself, the school was negligent in their supervision of this perpetrator?
Exactly, and I think that you said this a little bit earlier, that sometimes people are wondering why anyone else isn't the perpetrator responsible for their conduct, and the truth is, of course, absolutely. The person who commits the crime should be held criminally liable for their actions. However, when you're a parent and you're putting that child into school, you are putting that child into the school with the expectation that the school is going to keep your child safe. And so we look at holding everyone accountable who should have kept that child safe. And so there's always, there's the criminal avenue for the perpetrator, but unfortunately, sometimes there are administrators or other school personnel who had some knowledge and did nothing. And the only way to hold those people responsible are through our civil system.
Yeah. Can you give us, while we're on that, some examples of that, maybe like in a case that you've experienced, without specific details, right? But like of situations where you look at it and you go, oh, wow, like I can't believe they ignored X signs, right? And that's like information that they should have acted upon. And that's where you can kind of point to a school district being responsible.
So there are certain cases, I think probably less common, where you have what we would call actual notice, meaning the school actually knew that this teacher was engaging in inappropriate conduct with children. Things like complaints from parents, complaints from students about, I don't want to be too graphic here, but there can be all kinds of things, but things where the school had actual knowledge. That's kind of the lesser situation. I do have a lot of cases where that has happened, but you might also have cases like the case you and I worked on. Kenny and I worked on a case where we had a teacher who had abused multiple students over a course of many school years. And so you have conduct that, what we would call red flags, that raises red flags, things like sharing cell phone numbers with students. Teachers shouldn't be talking to students privately through Snapchat or different sort of avenues. Teachers who are taking kids in their private vehicle off site. Engaging in inappropriate conduct that may not be illegal per se, but that raise some sort of red flags and cross boundaries for a teacher-student relationship.
Right. And it's information that gets brought up to the attention of administrators, right? And they don't act on it.
Correct. They either ignore it or they, let's just say ignore. They ignore it, or sometimes they brush it off as, they might even address it with the teacher, but they don't necessarily address it in a way that's going to keep the students safe and protect the students.
Right. All right. So one of the things that I think is important, I think helpful to discuss, is that when victims are considering bringing a lawsuit, right, and attorneys working on these cases, victims often are concerned with what's going to be said about them, right, and how they're going to be portrayed. And I know one thing that's really big here in bringing these sort of cases and ultimately in trial and what gets brought out and what doesn't comes to light is a lot of times defense attorneys, I know in the past, and I'll let you speak to kind of what it is now, is that they try to paint the victim as someone who gave consent, right? As someone who encouraged this. It's a horrible argument, but what is sort of the law surrounding those that type of positioning now?
Yes. So, well, I think it's common sense, but a child cannot consent to sexual acts with an adult. That's just common sense. And we know that by the law. When you're under 18, you can't consent to having any sort of sexual contact with an adult. However, we do have the Code of Civil Procedure does provide that a defendant cannot argue consent. They can't say that a child who is sexually assaulted or abused by an adult has consented to that conduct when that person is in a position of authority over that child. So just like it's teacher-student relationship, they can't say, well, you were in a relationship, you wanted to go out with him, you made those decisions, and so therefore you are not harmed, or the school's not liable. So yeah, they're not allowed to make that defense per the Code of Civil Procedure.
Yeah. All right. You mentioned, we talked a little bit about AB 218. I know that there are also some attacks on it now. There are current attacks that are going on. Can you talk to us a little bit about that and why it's important for people to kind of keep that in mind and what we can do about it?
Yeah. So if you are litigating AB 218 cases right now, it's probably come to your attention or come across your desk at this point. But what is happening is these public entities are arguing that the retroactive application of the elimination of the claims presentation requirement is an unconstitutional gift of public funds. So that's a mouthful, but essentially what they're arguing is that when you eliminate the claims presentation requirement retroactively, you have now created liability for past acts where there was no liability prior. Mm-hmm. So now you're making an unconstitutional gift of public funds. And they're saying that it's a gift now because there was no liability back then. Now there is. Now, I wholeheartedly disagree that we're creating liability where none existed, because at the time when the abuse occurred, there was still potential liability for these school districts if they were allowing negligently a teacher to commit sexual abuse of a child. However, even if you were to accept that as being true, that it created liability where none existed, if there is a valid public purpose for the gift of public funds, then it's not unconstitutional. So there's an argument to be said that when you look at the legislative history of AB 218, the public purpose behind the elimination of the claims presentation requirement, the extending of the statute of limitations, and the entire reason for AB 218, it serves a valid public purpose. Absolutely. So that's the argument that is being made on the other side, that there is a valid public purpose for the enactment of the law. So therefore, it's not unconstitutional. So right now, there's been a lot of, I've opposed, I couldn't even tell you, dozens of MJOPs at this time, motions for judgment on the pleadings, motions for summary judgment, demurs, and been pretty successful. There've been a couple losses along the way, but it's already going up through the appellate courts. So hopefully this issue will be resolved sooner than later.
Yeah. Goodness gracious. Okay. Well, thanks for that. That's it's one of those where, like, if you're not working those types of cases on a day-to-day basis, right? Really not in that area, you don't. All we sort of know is, well, there's this great law that passed that now there's an extension of statute of limitations, but quite in fact, there's obviously some opposition now trying to eradicate any of those. I don't want to say benefits, because nothing in this area is a benefit, right? But those options that have become valid and available now for victims.
Yeah, it's it's of course disappointing to see attacks on it, but to be expected, because I think a lot of public entities they've seen an influx of cases and they don't want to pay for them. So unfortunately, that's where we're at. But if you are still litigating these cases, we are pressing forward. We're still getting good results. We're still getting cases settled. So it's not all gloom and doom. It's not, nothing to worry about too much. We just keep pushing forward.
Right, right. Okay, well, speaking of pushing forward,
Yeah.
can you give us some of, you know, tips for litigators in perhaps as they go through a discovery phase, as they're litigating these cases? What should they be looking for? What should they be asking for? You know, you're someone who is very well seasoned in this area, and just I think any tips and advice coming from you would be very valuable for litigators.
Yeah, thanks. I think that importantly, obviously, is getting as many documents as you can get. These are cases where sometimes they'll come across your desk and you hear, this teacher abused this child, and you think that that's all you need to know. Well, that's not all we need to know. The inquiry doesn't end there. We need to figure out what the school knew or should have known. So gathering as much information about the alleged perpetrator. When you are asking for documents and discovery, you don't want to just ask for a personnel file. School districts are very clever in how they maintain their records, and a lot of
Mhm.
documents are not kept in a personnel file. You aren't going to get complaints, investigations. You may get formal discipline, but not everything results in formal discipline. A lot
Yeah.
of things don't result in formal discipline. So you need to be very broad about what you're asking for,
Yeah.
but also very specific. I know that might be contradictory, but you
Not for
have to.
not for attorneys. Yeah.
Exactly. I mean, there isn't a stone you can't uncover, because I took a PMK depo today of someone within a school district and asked for specific documents, and I don't think he was being dishonest, but then as I was asking questions, I figured out he didn't check a certain database that
Um,
contained records pertaining to my perpetrator, so I had him go do that, and he gave me 4 more pages of documents that were missing.
yeah.
So, um, it's I'd like to give people the benefit of the doubt that they're not being sneaky. However, documents aren't all kept in a pretty little file in one location. So it's really important that you
Right.
be very over inclusive and also very specific about your document request.
Uh,
Um, I would also recommend getting, if you're looking for if you're dealing with cases with maybe abuse that took place some time ago, you want yearbooks, you want
you
class
didn't
photos, you want to find as many people who went to this school
okay.
while your plaintiff was there, but also predating your plaintiff. You want to know what the school knew before your client was there about this particular alleged perpetrator. And kids talk more than teachers, so you want to find everyone you can find. These cases are very discovery heavy, because there's a lot you need to find out, there's a lot you need to investigate.
Good.
So finding as many people as you can and talking to as many people as you can is really important.
Can I ask you something on that? Are
Yes.
you as attorneys, you know, people sometimes have different philosophies on this, but like or maybe it depends on a case to case basis, but are you as the attorney also reaching out to some of these folks, or we just have investigators reaching out to these folks, or does it matter when in the sort of litigation process you're at?
So I prefer to use an investigator to
Okay.
make contact with potential witnesses for a number of reasons. I think that, you don't want to end up being a witness in your own case.
Yeah.
So if you can utilize the services of an investigator, that's probably better for you. Um, I
Sure.
don't love to just subpoena people, but you'll have people who are not particularly helpful or willing to talk to you. So sometimes you have to go that route. Obviously, we'd much rather have a friendly witness, but sometimes if you need their testimony and they're important to your case, you
Yeah.
just got to get them served.
Yeah. Yeah. Okay. So we have documents, and knowing that, you know, it's not all kept in one place, and so we have to be broad and specific at the same time. And witnesses, I love that the tip about yearbooks, and because there's so many people, and you're right. I mean, thinking back to our time as in grade school or high school, all of that, it's like, yeah, everybody's talking, everybody knows what's happening because the information just gets spread from one student, from one class to the other, right?
Yeah. And I remember I had a teacher who I later found out was unfortunately arrested and convicted for child sexual abuse. And,
Mhm.
when you think back to your time in that school and with that specific teacher, and then you remember people talking about so and so, kids just talk.
Mhm.
Kids talk. And you'll never know what you can uncover if you don't go and try. So it's important to go find all of those people.
Yeah. Yeah. All right. Well, Allegra, thank you so much for
Well,
your time. Thank you for spending. I know you're very busy, and you just got done with the PMK depot, so I know that was a fun, day, and you're a little tired. So,
yeah.
thank you for doing that.
Of course. Thank you for having me on and letting me talk about, my favorite subject, which I know
Yeah.
is such a strange thing to have be your favorite subject, but I really love litigating these cases and super passionate about it.
Yeah, and you know what? Before we leave, can you
Yeah.
talk to us a little bit about that? Because I mean, in full disclosure, you and I saw each other this past weekend. We were at a seminar out in Palm Springs, and we just kind of got to chat a little bit, and as we often do during that seminar. And um, you're very passionate about what you do, and you believe this to be very important, and it is. Can you share with us a little bit, and for everybody listening, just why this is so important, this work that you do, and the work that you do for these victims?
Yeah. Well, I think that for all of us that practice law, it's hard work. It's exhausting. Sometimes you're burning the candle at both ends. And I think it's just really important that you find an area of law that you love and that you believe in. And for me, I had no desire to become an attorney. This wasn't my life's plan. And getting now to work with people and navigate them through this part of their life, it means a lot to me. It feels like a privilege, honestly,
Yeah.
that I have, especially some of these clients who have never disclosed their
Mm.
abuse. They're telling me
Yeah.
intimate details about some terrible parts of their life. And I get to help them tell their story for the first time, to face the school district and tell their story and to be heard. And really bringing a voice to these victims is very powerful. And I feel very honored that they allow me to do that. And I feel very fulfilled getting to stand alongside these really brave individuals.
Yeah. And your clients are very honored to be able to have you.
I
Uh,
appreciate that.
So, Allegra, again, thank you so much for your time. If anybody is interested in chatting a little bit more about this area of law, sexual abuse in school district cases, please reach out to Allegra. If we have any folks who are listening and want to talk to Allegra about a potential case or something that happened in their past, please feel free to reach out to Allegra. It's Allegra Rineer at Herman Law. And once again, thanks, Allegra, for being on this episode of the Litigators Network. And to all of our listeners, we will see you on the next episode of the Litigators Network. Until next time.
Bye. Thank you.